Good evening. I'm Billy Tesek, the president of NAWIC Qatar, National Association of Women in Construction. I hope you're all well. On behalf of the NAWIC Qatar Foundation Board, welcome and thank you for joining us this evening. I would also like to extend a warm welcome to our partners and sponsors for joining us. Qatar University, Public Works Authority, Ashkal, GHD, Parsons, GSonic, ERGA, Turner Townsend, Qatar Financial Center, LCI, Lean Construction Institute Qatar, TMF, and Al Asmah Real Estate. This is our third webinar on construction contracts and claims. Before we start, I'd like to note a few points. The session is being recorded and will be available with a copy of the presentation slides next week. To receive your electronic attendance certificate, you will be required to attend at least 90% of the webinar. If you have any questions during the presentation, please type them in the chat box on the right-hand side of your screen. We will have a question and answer session after the presentation. In case we don't cover all of the questions, we will send you the answers next week with the presentation and the recording. We will do our best to answer everything tonight, but just in case we don't, you will receive the answers. The webinar will last for an hour and a half. An hour will be a presentation, and half an hour we will leave for questions and answers. And as always, we would appreciate your full attention and to stay away from distractions during this time. Also, as we go through the presentation, you can type your positive feedback with the plus sign, or any suggestions for improvement with the delta sign. We will use your feedback to improve our future events. And now we got to the most important part of this evening. Let me introduce you our presenter for this evening, Rouda Bazad. Rouda specializes in domestic and international litigation and arbitration and corporate and commercial matters. She has a particular interest in an alternative dispute resolution and is certified as a commercial mediator by the Chartered Institute of Arbitrators in London. Rouda graduated with the Bachelor of Law Honours degree from Newcastle University in 2011. Followed by a Master Law degree in International Commercial Law from Cardiff University in 2014. Before establishing her own firm, Rouda spent a number of years as a legal counsel for Qatar Foundation. In this role, she undertook a range of contentious and non-contentious work and was a member of the Tendering Committee and also a member of the Dispute Resolution Committee. As a result, she understands the interplay between legal practices and business and appreciates what in-house lawyers need from their external advisors. She continued accumulating experience in various sectors of law, both abroad and at home in Qatar, striving to distinguish herself through dedication, perseverance, and a proven track record of professional successes. Rouda will now take us through her presentation on the impact of COVID-19 on construction contracts. Rouda, over to you.
Thank you, Bailey, for this lovely introduction. Ladies and gents, I would like to basically take a moment to thank NAWIC for this unique opportunity to have me here in this. Actually, it's actually my first time. I've explained this to Bailey. It's my first time to present online. I'm used to like face-to-face interactions and seminars and lectures. So basically, yes, thank you, NAWIC, for having me here, and thank you, Bailey and Amna, for all of your support. And I would like to have basically a special thank you to Dr. Ghada Darwish for her constant support and endorsement. So basically today I'm going to talk about construction contracts claims, EOTs, and force majeure claims. So basically this particular topic is one of my favorite topics, to be honest, and it's one of my areas of expertise. So I would just like to give you a heads up. This particular lecture, I'm going to discuss more about the practical means and ways to overcome any conflict when it comes to applying force majeure claims, taking into consideration COVID-19 and the new changes, let's say the new global changes. Our lecture basically will discuss two main sections. The first section is what is a contract. I'm going to talk in depth about the elements of a contract and what are the golden keys of that would basically constitute a well-known, well-constructed construction contract. The second section of this lecture will discuss about what is force majeure, how could force majeure affect the contract, and how we can basically implement it and execute force majeure, taking into consideration the impact of COVID-19. And basically, I will implement few examples of how to draft a force majeure clause and what are the key points that you should take under consideration when drafting. Moving on to the next slide. What is a contract? Basically, all of you, what is a contract? It's a very simple question. However, it means a lot of things. A contract is basically a legally binding document that recognizes and governs rights and duties of parties to the agreement. A contract can be either oral or a written contract. An oral contract is basically implemented in our daily lives. Basically, every day you would intervene or let's say have an oral agreement from, let's say, taking your car to a petrol station and having petrol, for example, all the way to going to a shop in Suq Waqif and buying a t-shirt. Oral agreement is something that we do constantly without even basically knowing it. As for a written agreement, it's basically it's a standard thing where two parties come together, or even more than two parties come together, where they highlight all of their obligations, duties, and requirements, giving, let's say, an issue date of the contract and an expiry date of the contract. But to be more specific, because for construction contracts, my recommendation is always to have a written contract in place. Oral agreements, however, can be a little bit challenging to enforce, and especially taking into consideration the nature of your business. With oral agreements, sometimes you would forget some of the details. Sometimes you would have denial. Always you have to lower your expectation when it comes to having an oral agreement in construction contracts. I'm talking about purely small projects, not the big projects. So basically here, I managed to gather around a few key information about what should we basically include in contracts. Obviously, we have an acceptance and an offer. Without acceptance and offer, we don't have a binding contract, to be more specific. An acceptance is basically, an acceptance and offer can be implemented as an example. You have party A offering to sell his car, let's say, with 10,000 riyals to party B. An acceptance is where B show his, basically, he would show that he accepted such offer and he accepted such price. Obviously, we have also a promise to perform, where A would promise to have the car delivered by, let's say, Wednesday afternoon. A valuable consideration can be implemented in a down payment or issuing a check. All of this can be considered as consideration of such engagement. We have here also a time or an event when the performance must be made. So basically, in the contract, you always have to make sure to include the time and the event in which party B will fulfill his obligation under the contract. Obviously, terms and conditions related to the performance of the contract is very important, and it can be illustrated by providing several clauses that govern such terms and conditions. This is basically ties directly to the scope of work and helps basically the parties to understand how things will work in the future. Having a reasonable exit plan can be implemented in drafting a termination clause, for example. Let's say what would happen if both parties, one of the parties did not show up for work. for example, or one of the parties did not have the woods delivered on time. What is the reasonable exit plan? How we can terminate the contract correctly? This clause will basically, I'm going to talk about it in more details in the future slides. Yeah, moving on to the golden keys of the contracts. The thing is, those golden keys, you won't be able to see them in, or basically, it's hard for you to find them in textbooks. I was able to summarize one of the basically 5 or around 6 golden keys of a very well constructed contract. I'm going to show you how, let's say, legal counsels or even lawyers can review a contract, especially construction contracts, because they are really, really technical contracts. One of the main clauses is the governing law. So basically, when I have a piece of paper, let's say if I have a master agreement or a lump sum contract, for example, the first clause that I take under consideration when reviewing a contract is the governing law. The reason is because governing law is, let's say, it gives you a hint on based on what all of these clauses will be governed. Once you understand the governing law, whether this contract is governed by the English law or this contract is governed by, let's say, the French law or the Qatari law, each law in each jurisdiction implements different doctrines, for example. And based on the legislation, I'll be able to review and make sure and check whether all of these clauses are actually in line with such legislation or not. Here I have a brief definition of what is a governing law. Basically is a clause used in legal agreements where you can declare which rules and laws will govern the agreement. The second section is the dispute resolution, which is, it's usually the longer clause that you can find in the contract. Especially, it sets out the platform in which both parties, how basically they can settle any dispute that would arise during the terms of the term of the contract. It basically helps and guides the parties to solve any issues arising out or in connection with the contract. Here I have provided a very simple example of how a dispute resolution clause can be implemented in a contract. As an example, the parties shall attempt to resolve any dispute arising out or in relation to the contract through negotiation between senior executives of the parties. Okay, let's stop right here. Why do I like to, let's say, draft or let's say guide the parties into negotiation? The reason is because if you have an open dialogue and a healthy environment in which both parties can resolve such conflict regardless of the size of the conflict, if you have negotiation in place and if you have a direct connection, you'll be able to overcome any kind of dispute. Always, whenever a dispute arises, always keep it in writing and try to seek negotiation at the beginning. Another point that you should take under consideration is that such negotiation must be conducted by senior executives, i.e. people with, let's say, authority, people, decision makers, for example. Because in order for you to negotiate, you should always have to, let's say, have the authority to make such decisions and promises. Moving on. So basically, yes, senior executives of the parties who have authority to settle the same. This clause can be extended to include more details, such as, for example, if the matter is not resolved by negotiation within 30 days of receipt of a written invitation to negotiate, the parties will attempt to resolve the dispute in good faith through an agreed alternative dispute resolution procedure. So basically, as you are aware, that alternative dispute resolution procedures can be implemented in many, many ways. We have commercial mediation, and we have arbitration, and so on. As for termination, yes, I remember when I mentioned that you must have an exit plan. This is what I meant by termination. Termination is basically a clause used in legal agreements where you can declare which rules and laws will govern the agreement. And so basically, termination is basically a clause that would guide the parties to terminate or to seek earlier termination before, let's say, the expiry date is on. So let's say if you have party A and party B. Party B have reached their liabilities and warranties under the agreement. What could happen? You can always seek for earlier termination based on such breach. How we can do that is by implementing and drafting a proper termination clause. This clause will guide you on the ways and steps that you can take in order for you to terminate. Termination can be also conducted via a written notice to the other party for such breach, and it could always be guided with a timeline for such termination to be in action. Moving on to the next slide. The scope of work. Yes, the scope of work is basically a formal scope of work. You must always have a scope of work considering the nature of your business. And it should be clear, just basically drafted with simple business language. You know, stay away from having it too complicated. Stay away from drafting big words, big legal words. You know, the reason why is because the scope of work is basically a guideline that can be used and must be used actually by construction managers during the terms of the agreement. The scope of work basically talks in more depth and more detailed and more technical terms of, let's say, the state of all quantifiable data, let's say from the type of cement to the type of bricks to the specific criteria of all of the materials that you will be using in the site and for this particular project. Always make sure that you draft a clear milestone and divide the project into phases and sections. You can also include the project schedules and management scheme, who will manage the site, and based on how many reports should you be expecting. The last thing is basically force majeure, which is the topic that we will discuss in depth. Here I have also included few notes. Always plan your dispute resolution clause ahead. The scope of work should always mention as a separate, should be always as a separate clause from the master agreement. So basically you have a master agreement in place, and the scope of work could be used as one of the annexes, for example. Okay, so what is force majeure? Actually, the first people who actually came up with force majeure is the French. It was widely implemented under the French law, and it was firstly implemented in the French law. Force majeure is basically a French term that literally means the greater force. It is related to the concept of an act of God, basically an event of which no parties can be held accountable, such as hurricanes, tornadoes, flood, and it could also, we can also include human actions, for example, such as armed conflicts, riots, government lockdowns, as what we encountered in March, for example. Plagues and highly infectious diseases, for example, can be also included. So it's basically any force that it is basically beyond the control of the parties of the contract, and it was unforeseen at the time of the contract, and it is obviously unavoidable. So basically, if we're going to take an example of a hurricane, let's say in September, two parties have signed a contract. The weather was beautiful, obviously. They live in an area that they don't see a lot of hurricanes or tornadoes, for example. And they never expected that this particular incident would happen. During the terms of the contract, A decided to ship, let's say, a container to B, as promised in the contract. And all of a sudden, a hurricane came in and destroyed this container. So obviously, this is like a very simple example of what we mean by force majeure, something unforeseen, external from the parties of the contract, and unavoidable. So basically, those concepts are defined and applied differently depending on the jurisdiction. Since basically we live in Qatar, I'll give you what the Qatari legislation actually define, how they basically identified force majeure. Force majeure was identified in law number 22 of 2004 under the Civil Code. To be more specific, it was actually identified in Article 188. I have here quoted the exact words of what Article 188 has stated. It says that in a contract binding both parties where performance of an obligation by one party is extinguished by reason of impossibility of performance. Okay, so basically based on what? Due to the force majeure beyond the control of the parties. So yes, so it's either you have a situation where both parties signed a contract and the force majeure incident occurred, which made it beyond the control of the parties and made it impossible for the performance as governed by the government, as governed by the contract. Such obligation shall be extinguished and the contract deemed resigned. So basically the wording of Article 188, to be more specific, also implements similar conditions as of the French jurisdiction does. Basically, you have a condition of being impossible to perform, which is one of the most important conditions. You must also prove that it was beyond the control of both parties and something that was unforeseen, basically, i.e. it was not expected. Article 188 gives the discretion of either parties, or let's say the injured party, to seek one of the three, either suspend the contract, cancel the contract, or terminate, basically seek for earlier termination of the contract. Here I have included a question, but what if such impossibility is partial? So based on Article 188, the Qatari jurisdiction gives the party the discretion to seek or let's say demand the termination of the contract or partial termination of the contract, depending on the situation. Yeah, to sum up, basically the conditions as per Article 188 is those three. Number one, it must be unforeseen by both parties when they enter the contract. And number two, beyond the control of the parties. And the third condition is the impossibility to perform their obligation. All of which can be determined by the judge in a situation where the contract does not govern, if the contract did not include the force majeure clause, which can actually make your life easier. So yeah, here in this slide, I'm going to talk about how could force majeure affect the project. So basically, yeah, force majeure can affect the project in a practical way by one of the three. So either you seek for total or even partial termination. You may also suspend or let's say seek for suspension of the performance. And the third one is the extension of time, which is the most practical way to move forward in case force majeure occurs. So basically, here's an example that maybe one of you guys encountered it. So let's say if your workers were not able to report to the job due to the government lockdown. So basically, an example of that, we had by let's say the end of March, I think there was a lockdown of all of the industrial area. A lot of construction companies were affected by this because they could not reach to their workers. All of the materials were stored in the industrial area, which affected them directly. So basically, what could happen if this situation occurred? You might be able to get an extension of time based on their inability to work or let's say to report to the job site. So basically, it depends on how the force majeure clause was initially drafted. And contracts on how the events especially affect the work. In a situation where your work could continue, the force majeure clause may not be applicable. So let's say basically you are located in Doha, okay, and all of your workers, they live in, for example, Mughwalina. The job site was in Old Airport or Al Hilal. By that, the government lockdown would not affect you directly. It would basically affect those who live in the industrial area. So basically, the answer is, does, let's say, Corona can be illustrated as one of the situations where force majeure can be applicable to our scenario? The answer is no, depending on the nature of the scenario, depending on what actually happened. Ultimately, the lockdown did not affect you directly, since your site was not around the industrial area, for example. Okay, here we have the execution of force majeure, how we can execute it in practice. Okay, so basically some contracts provide specific instructions. Always return back to your contracts. Have a quick look on the force majeure clause. What does the force majeure clause say? Does, let's say, this particular clause affect me personally, and how we can show or how we can implement it? Let's say in a best scenario where force majeure actually covered COVID-19 and the plagues and other things, and the force majeure clause gives you the right to, let's say, go back to the other party and express everything via written notice and seek for earlier termination, you may do so. Having a written notice is quite important for two reasons. The first reason is that you can use it as a proof in a situation where the case was escalated and was referred back to the litigation process. Number two is always use a written notice to open up, let's say, a dialogue with the other party, and try to sit together and find the best solution and the best way forward. So basically, yes, let's say in a situation where, okay, we had, I have my factory in Sanaiya, for example, industrial area, and my workers could not report to the site. And based on that, and based on this governmental lockdown, I have suffered some delays, or basically it made it impossible for me to pursue, or let's say to report back to the site. What should I do at this stage? My recommendation is to draft a written notice to the other party, or let's say, i.e. the owner. Basically identify the specific act of God event, talk a bit more about COVID-19 and how does it affect your project, to be more specific. Always show that why you were unable to perform, or let's say stay on schedule. The third section of the written notice, you must include how you were, did you try to find alternatives, or let's say hire a subcontractor who doesn't live in the industrial area, for example. Were you able to do that? Yes or no? You should also include it in the written notice. And number four, basically recommend the way forward, recommend the solution, and see what they have to say about it. Should you cancel or terminate, or seek for an extension of time? Depending on the situation, recommend a better solution. So yeah, here I have an example of how we can draft a force majeure clause during the pandemic, or let's say related to any infectious diseases or something like that. Please note that this particular language was adapted from the ICC model clause. So yeah, it says here that unless otherwise agreed in the contract between the parties, expressly or impliedly, where the parties of the contract fails to perform one or more of its contractual duties, the consequences set out in this clause will follow in, only if and to the extent that the parties prove. Here I have provided three situations. Number one, that it is a failure to perform was caused by an epidemic beyond its reasonable control. So yeah, again, remember the conditions that we have discussed. It must be beyond the control of both parties. Number two, if it could not be reasonably have been expected to have been taken the occurrence of the epidemic into account at the time of the contract. So basically, yes, when you were drafting the contract, did you expect it? You must show that it was not, basically, it was not anticipated. Yes, obviously, COVID-19 was not anticipated at the stage. And the third, The third point is, sorry about that. It could not be reasonable to avoid and to overcome the effects of this epidemic. So yeah, going back to the slide, you may extend the clause to include plagues, epidemic, pandemics, outbreaks of infectious diseases, or any other public health crisis. This obviously, those exceptions can also be included as an example of what is basically understood as force majeure. Besides including floods, an act of God, or hurricanes or tornadoes, for example, you can include these exceptions as well. So there was a question that I usually come up with. I come across a lot. How could recession due to the coronavirus triggers force majeure clauses? And could this actually, basically recession, could be considered as one of the causes of force majeure to be executed? The answer is no. Why? Because recession is something predictable and something could happen at any time, whether we have corona or we don't have corona. It's something that usually happens between time to time. So yeah, it does not satisfy one of the three conditions that we have discussed earlier. As to conclude, those are few so those are few points that I would like you to take under consideration when drafting the contracts, or let's say reviewing the construction contracts. Always include the builder information, the description of the project, and how the money will be paid, how the payments will be arranged by installments, when and how. Always include additional information about the materials that will be used in the site and a proper time frame. Include also penalties and force majeure clauses and dispute resolution. Once you have all of this covered in the contract, hopefully you will not come across any issues in the future. Basically, if you have a well-constructed contract that governs everything that could and may happen in the future, you'll be in the safe side. So anyways, I hope you have benefited from this quick lecture. And if you have any questions, please do not hesitate to ask.
Okay, we do have a few questions. So, can a client terminate the contract based on the current situation in the country?
Sorry, can you say that again?
Can a client terminate the contract based on a situation in the country?
What kind of situation do you mean?
COVID.
COVID. Yeah. As I've said earlier, depending on the situation, obviously, depending on where they stand right now. If, let's say, they have satisfied the three conditions that I have expressed earlier, then yes, they may seek termination based on Article 188 of the Civil Code that we have.
Okay, so that stands as their right.
Depending on the situation. If they satisfy the three conditions, i.e. it was impossible for them. Yeah. If they reach the, let's say, the degree of being impossible for them to perform their duties as per the contract, then they can, yes.
Okay, which leads us to another question. What if one party refuses to conduct the termination, to participate to accept the termination?
So basically, let's say in a scenario where they have emailed them, or let's say send them a notice letter saying that they would like to seek earlier termination, and the other party have declined such a request, yeah?
Yeah.
So basically, as I've said, depending on the information of the client, you know, depending on the scenario, if they have done all what they can do to make this happen and to fulfill their obligation, However, due to the, let's say, the government lockdown or something beyond their control made it impossible for them to fulfill their obligation, by all means, regardless if they accept it or not, they can seek early termination based on 188. However, it is highly crucial for me to state this. The application of force majeure can only be used by him. So basically, it cannot be determined by the judge. Yeah, you must use it as one of your defense mechanisms.
Okay, and Rhoda, from your experience, in if the contract gets terminated and the contractor does not believe that that's the right decision, or they feel they feel done by that decision, apparently they if they submit a complaint or to court, the court will stop the client of any actions on the site until the situation is resolved between the contractor and the client.
Yes, but what they can do is, are you talking from an owner perspective or a builder perspective?
Let's say both, from the owner perspective.
Okay, so let's say from the owner perspective, what they basically what they can do is raise a claim and take it to the urgent matters. I don't know how to say this in English, but we call him قاضي الأمور المستعجلة. So basically, they can raise a claim. We call it إثبات حالة, which is basically a screenshot of the current situation of the site, and they can basically contract with another builder to finish what the previous builder have already started. Basically, it gives him a flexibility to manage this situation, and then basically he can seek for penalties or any kind of claims that he find necessary at the stage.
Yeah. Okay. So does it mean that it's actually if the owner goes and lodges that claim first, they will be on the front foot in terms of being able to replace the builder?
They can replace him, but they must have a justification for that.
Yeah.
They can, but depending on this. But even though if the builder did nothing wrong, they will be obviously in breach of the contract. So it's like having a termination and finding another builder. But then again, you have payments to fulfill. You have your obligations as an owner against, let's say, the builder at the stage.
And from the builder's perspective, if the contract gets terminated and they feel that was not the right decision, if they go and lodge that claim, what is the consequence to the site and to the owner?
So let's say they were a victim of wrongful termination, you mean? Yeah?
Yes.
So yeah, at this stage, let's say, depending on what kind of damages that such early termination or unlawful termination happened, so they can seek for these damages, and they can seek for reimbursement of whatever they have paid during this period of time. Yeah, so basically, as I've said, in this situation, in a scenario where you have a wrongful termination, basically by that you just have to show that the owner was in breach of the contract, and you would seek the required remedies for such breach.
Okay. Okay. Another question. Can heavy rain be considered as force majeure? No.
No. I'll tell you a funny case, yeah?
Yeah.
I think somewhere in the 80s, I'm not really sure about the dates, but there was a contractor, a Spanish contractor, and he was hired to build like a train, what do you call it? Like a runway or something like that? Like a train platform in one of the Middle Eastern countries. What happened was they started their project during the summer, and obviously the workers could not handle the heat. So they wanted to seek for frustration, saying that I was not able, it was highly difficult for me to fulfill my obligation. And they wanted to terminate or seek early termination for frustration. The judge basically overruled and said that obviously you seeked a job in the Middle East, and it is expected for Middle Eastern countries to have high temperature heats and unbearable summers. This is basically does not fulfill does not fulfill the three conditions as I've mentioned earlier.
Mm-hmm.
So yeah, heavy rain is something anticipated, something that could happen at any time.
Yeah, for example, Rhoda, some contracts, and I know for contract in New Zealand, construction contract, we have allowance for 5 or 7 rainy days. And if the weather prevents the contractor to do the work any longer, they are entitled for extension of time.
Oh, the thing is, it's there's something. I mean, there's a thin line between what is considered as force majeure and what is considered as frustration. This example can be considered as frustration, for example, where it is not, okay, it's not anticipated, for example, whether it's anticipated or not, but either way, it made it difficult for either parties to fulfill their obligation. Whereas force majeure made them impossible. As I've said, 188, it expressly states that it must be impossible, not difficult, impossible for them to do. So basically, let's say, remember last winter we had heavy rains?
Yes.
There was a lot of cases regarding that. They wanted to seek frustration, and some of them, we call them al-halat al-tari'a. So it's quite different. It's not force majeure. It's something else.
Yes.
It falls under the judge's discretion. So basically, the judge would take each scenario at a time, and he will take all of the facts, obviously. If let's say it was difficult, it was highly difficult for either parties to fulfill their obligation under the contract, what the judge would do at this stage is either he would decrease the obligations to drop them a little bit down, or he would rule for an extension, or he would rule for an increase of the price in case there was additional costs due to this unforeseen events, which made it difficult for either parties to fulfill.
Yeah, and also, I mean, when it comes to even if the contract, allows some consideration of weather conditions and sort of inability to carry out work, there is always the assessment that is carried, whether or not there was work that could have been carried during that time, and whether or not it really affected the critical path, before anything is, approved or accepted or, paid. So, and that's, that's just between the client and the contractor. And then if they don't agree, of course, then that escalates to a dispute and to sort of different venues that can be taken under the contract. Which takes us nicely to the other question, alternative dispute resolutions. I love that. I love the sound of that because it sounds like very practical. It sounds helpful. It sounds faster. Can you tell us what alternative options are available?
There are plenty. Basically, when it comes to, I mean, do you want something more specific for construction contracts, for example?
Yes.
Yeah, we have arbitration actually, which is one of the go-to when it comes to disputes. Let's say construction disputes. We have an example, Hamad Airport, for example. Shara Salwa Road. It was one of the famous arbitration cases. So we have Sidra as well. Sidra construction contract was taken to arbitration as well. So the reason why a lot of, let's say, builders and owners, they're more attracted to arbitration more than litigation, considering the nature of the contract, is because construction contracts are very technical. Yeah, you would need obviously an engineer or an expert and basically act as a judge at this stage. So a judge would never know. I mean, the judge is an expert in law, for example, but he would never know how a pipe of the size of 9 millimeter could actually affect. He would just say, okay, pipe is a pipe, you know. But the engineer actually knows that. When you talk about construction, you're talking about detailed information that requires a different eye, not a legal eye, more of an engineer eye, you know. So that's why they're really attracted to go to arbitration, because it gives them this flexibility. And also arbitration is more flexible when it comes to the jurisdiction. It gives both parties the freedom to choose which seating and which jurisdiction can be implemented on their contract. So basically, this can be in France, and let's say the governing law of the contract can be as per, let's say, the English law, for example. So, yeah, so arbitration is quite famous. However, commercial mediation is quite interesting as well. Especially, it's commonly used in Europe. I've seen it a lot in Europe. Now in Qatar, or let's say in the Middle East, in our region, is I mean, it's not that famous. However, it's very practical. In Qatar, for example, they use mediation to resolve family disputes. It's actually enforced. You can't seek divorce unless you go to a mediator at the beginning. It's one of their procedural ways to resolve any family disputes. Commercial disputes is quite famous in England and in many Western countries. It's cheaper, obviously. It's cheaper than arbitration. A lot of people find it's more successful, and especially if you want this project to be going. Yeah. So basically, you have a conflict, a very minor conflict. You don't want this to affect the big projects. So mediation, one of the, let's say, peaceful means to solve the dispute. It's I don't know. It's not like a guided negotiation. It's more of a mediated, a mitigated seating where you would sit and discuss this matter. And obviously, it's not enforced, not legally binding. However, if it's signed via, let's say, another contract where you would set out all of the new duties of both parties, then it will be legally binding at the stage.
Okay. Okay. In terms of involvement of external advisor in obviously the client is the clients are the ones who select the contracts and the contract conditions mostly. So the contractor is there to, you know, whether or not they have any power to change anything or don't have any power. The advice of you know, taking the external advisor on in terms of how that contract is handled, recognizing, you know, the areas where they need to pay attention to, and sort of guidance on how to manage, you know, sort of there are no comebacks from the things that may be a little bit onerous on the contractor. How, in your view, you know, what is the required, you know, because obviously, you know, a lot of contractors will be mindful of cost, and but you know, very often it proves that, you know, paying for some advice upfront is a lot cheaper than you know what it can turn into later on if it's not managed properly. So what would be your advice in terms of involvement of an external advisor as a sort of as somebody who reviews, identifies the areas that need to be you know, the sort of monitored or carefully managed, and also to devise a strategy, you know, throughout on claims, especially if they have, extension of time claims, associated cost with time, and any other things that may not be clearly covered with the contract conditions?
To answer this question, I would like to highlight that there are plenty of types of contracts. Like for example, we have like something called like a lump sum contract. There are like plenty different types of contracts, construction contracts. We have like a time and material contracts, for example, like a unit price contract, where this specific contract, they list out the unit price, and they give more details about how many wood they would need, what are the prices at the beginning. We have also a cost and a cost plus contract as well. So basically, depending on the nature, or let's say which type of construction contract that you have. However, when mentioning the external contractor, you said, yeah, external contractor.
Yeah.
It is like, it's obviously almost every project, both parties would agree at the beginning on let's say an expert at the beginning. It's basically a person who would have a closer look on the site. He's, let's say, a mutual person. He's like a third party, which is not directly involved in the contract. However, he will work as a supervisor and to make sure that the builder is on check and the owner is on check. So yeah, it's highly recommended. The reason why is because you would always need, let's say, a mutual advisor, someone who would also be, let's say, I don't know, it's like a witness or something like that, You can use him also, his reports. I've seen a lot. They use their reports to prove a certain point, or to prove whether the owner was liable or not, or whether the builder was actually, in fact, in breach or not. So choosing the proper external expert at the stage, let's say at the beginning, before even drafting the contract, is highly critical.
Yeah. And here is the last question. What was the during the COVID? What in terms of number of cases? What is the have the cases increased in terms of construction claims, and were they any of them accepted as force majeure, and how it's generally COVID-19 claims, how they're generally treated, and how do you know how many of them have reached the court?
Plenty, actually, plenty. We have like many cases, actually almost around 45% of the claims, civil claims now, are related to construction. Obviously directly related to construction. However, is there any verdict right now? No, because it's an early stage. Maybe I can answer this question next year for you. But yeah, we have a lot of cases regarding this particular state. Obviously, as I've mentioned earlier, when it comes to procedural law, let's say the doctrine of force majeure can only be proven by the injured party. Obviously, at this stage, or let's say considering our scenario here, the builder is the one who can prove whether he fulfills those three conditions that I have mentioned earlier or not. He must provide proof, reports of, let's say, external contractor. He must prove that he have done what is necessary to try to fulfill his obligation. However, he did not succeed, and based on that, he would like to seek for an execution of the force majeure and a termination, or let's say to cancel the entire agreement, based on what Article 188 provides for. So yeah, the answer is yes.
Okay, and in terms of when a dispute arises, in terms of time frame, when would you advise or suggest that thing is escalated time-wise to the to the sort of arbitration? Immediately, trying to work it out, how long would you consider reasonable to work on dispute before you actually it gets escalated to a higher legal levels?
As I've mentioned earlier, identifying proper means of communication is highly critical at this stage. Yes, COVID-19 is something that was not anticipated and was not predictable. Actually, it came as a surprise for all of us. A lot of businesses have lost their profit, and some businesses actually they had to close down. A lot of employees lost their jobs, and obviously a lot of sites were handover dates were actually delayed due to this pandemic. So you're talking about an area that's it's basically I mean it's something new, yeah. So when it comes to, like, let's say if you're during the contracts, yeah, you did not anticipate that the COVID-19 would affect your site or affect your deliverables. Like, my recommendation is always seek a proper means of communication at the first stage, at the very beginning. As soon as you hear that there was a government lockdown, you should communicate it to the owner or the owners, for example. You know, some contracts that you have the owner, the site manager, you have another company, you have the designer, you have like a lot of parties. So you as a builder, you must communicate it to the other parties that, okay, look, we have an issue. This is a new issue. It obviously affected us. I can't reach my workers. My workers can't report to the site. I can't use my trunks. I cannot import or, let's say, export anything. So we have an issue. Always put it in writing. Yeah, you can use it as a written notice to the parties. Basically, talk in depth about the issue. How does it affect you? And were there any solutions that you would recommend, either to seek an extension or to increase the price, for example? That you can provide another solution where, okay, I can hire someone in Doha, but I cannot use my workers. Are you willing to pay additional price for freelancers, for example, instead of using my own workers, if you want something to be completed in time? So this is one of the solutions that you can implement. This would help either. I mean, it will help you in many ways. One of which you can also show this. I mean, you can take it to court. Let's say in a situation where you had a very difficult owner, yeah, and he chose not to accept this situation, or he was not understandable. You can use this written notice as an evidence in front of the court. This would obviously show that you were serious and you tried to resolve the matter, as you gave out solutions for that. And obviously it will show your frustration and the fact that it was impossible for you to fulfill your obligation because the owner at this stage have rejected all of your solutions or suggested proposals. Yeah. So what? Before the negotiation, my recommendation is at the beginning, when you draft the contract, never sign a piece of paper without having a lawyer to review it. I'm not advertising on myself. I'm just saying this for you guys' sake. You should take it to a lawyer. Have him read it, even if you have a family member with a legal background, someone who knows something about construction, or someone who's expert at this particular area of law. Have him review it. Obviously, if you have let's say a legal involved, it will make your life easier. Yeah, because the thing is, having an attorney review your contract, the attorney would think in a very different perspective. He would think about the worst case scenarios. Yeah, so he would include clauses that would help you even if the worst would ever happen, even if there was a conflict in the future, in a situation where you wanted to seek earlier termination. Because from, let's say, a psychological perspective, the parties at the beginning, they're quite anxious to sign the contract. They want to have the builder, he wants to have his first installment, and you have the owner wants to have things working out. You know, he wants to see builders starting with the site because you have a lot of things in mind. He wants to sublease it, and he wants to do this and that. So this is what they call it, the honeymoon stage. So basically, everyone is happy. Okay. But what could happen? I mean, you have to always think about the worst case scenario and propose a platform and propose a clear path in which both parties can take in a situation where something went wrong during the terms of the contract. So my recommendation is to have a properly drafted contract, to have a lawyer review it, and in a situation where COVID-19 happened, or something else could happen in the future, always keep it in writing. Always notify the other party. Try to negotiate it at first. Make sure that the people who will enter this negotiation are people with, they have the authority and the discretion to make such decisions. Stay away from litigation. This is my recommendation. It's time consuming, it's frustrating. Obviously, you will encounter a lot of delays, a lot of pending tasks, just for the sake to have a ruling. Yeah. So always go with the mutually and well-constructed negotiation plan before entering into a conflict.
Yeah. Okay. I think that was we have covered all the questions. So I would like to, Rhoda, thank you for your time and for you sharing your expertise with us this evening, and present you with the appreciation certificate.
Thank you, dear. Thank you very much.
Yeah. I hope the audience have enjoyed, and you have given us some very clear advice on how to handle it, how to prevent it, what does it mean, whether or not it's worth to consider it or not, and really how to manage the situations that are outside of what we expected, but not necessarily covered by force majeure. So as such, we already have some feedback, and it's great. So thank you so much, Rhoda, again. And we will catch up and see you again at some stage, and then we can share more sort of more of how it unfolded and developed over the time, what we're now experiencing as new. I will also take the attendees just to advise you on what's coming up. So next month we will have a webinar on the new Qatari labor law. So we will present on the changes and how they benefit and how they're handled, what is the new process, how they impact employees and employers. And also next month, more precise, on the 13th of November is our first anniversary. So it's going to be NAWIC Qatar's first birthday, which we're pleased about. Yes. Yes, so please stay tuned for information on the future events through our social media. And hopefully we will be back to the live events very soon, and we will be able to sort of network in person. But we are very grateful to have have what we have, and to have experts like Rhoda being able to join us this way. So Rhoda, thank you so much again.
The pleasure is mine, dear. Very much.
Thank you, everybody, for joining us this evening. Stay well and stay safe. Good night.